number 99 on the calendar, matter of the Honorable Terrence C. O'Connor. Counsel?
Good afternoon, Your Honors. May it please the Court, I'm Jonathan Edelstein, and I represent Judge Terrence O'Connor. With the Court's permission, I would like to reserve 3 minutes for rebuttal.
You may.
Your Honor, in the Kiley case, this Court emphasized the need to, quote, minimize the risk.
Counsel, what steps did the judge take to cooperate with the Commission's investigation?
He made a detailed written response to the initial investigative letter, a sufficiently detailed response that the Commission used part of it against him at the hearing as an admission. And in fact, there were further details in that response regarding, among other things, the right to be heard and the imposition of the fees that were not entered into the record before the Commission. And he did participate via written submissions. Your Honor, I'm certainly not saying that he handled this well. I think that this case is proof that even a judge is not immune to pro se litigantitis.
Does he now accept responsibility for his failings in regard to cooperation with the Commission?
Well, Your Honor, I'm not sure that I'm not sure that that's relevant at this late date, given that the record has been made. I mean, certainly in discussions with me, he has acknowledged that he did not handle it well, and that he should have retained counsel sooner, and that he should have cooperated more fully in the process. But what I would like to come back to, Judge, is that in the Kiley case...
Aren't you missing... The real point here is, leaving aside the individual allegations against the judge, the point is that how can the Commission or any monitoring agency in dealing with the judiciary come to any rational decision and make any recommendation to us if there's no cooperation to begin with? And that refusal to cooperate almost undermines our ability to give you a judgment.
Well, Your Honor, I think you've just outlined very clearly why non-cooperation is its own punishment. Mm-hmm. And also why the Commission has other remedies in that circumstance. Non-cooperation can result in an adverse inference. The Commission may treat failure to respond to allegations as an admission. It did not do that in this case, but it can and it has done in other cases. In addition, failure to testify. Again, this is not a case of complete non-cooperation. This is a case of failure to appear and testify. Mm-hmm. Also results in lost opportunities for Judge O'Connor.
To me, it potentially goes beyond failing to appear and testify, because there were a lot of there was a lack of response to written requests in a timely manner. There was just providing information that, so not only was there failure to cooperate, but and I think the Commission certainly reached the conclusion that it was an intentional attempt to delay and frustrate the process. It wasn't just a, sit back and ignore it. I can't deal with it. Whatever. It was very intentional. It certainly can be interpreted that way.
Your Honor, I would in fact suggest that there is not enough evidence to interpret it that way. I know the Commission reached that conclusion regarding the misaddressed envelope. And regarding the four...
There was also, arguments that he was waiting for an executor to be appointed and that he couldn't proceed without certain information, which he never really explained what that information was, since he had all the information, and he, requested adjournments and then didn't show up on adjourn dates. So it's more than just...
Your Honor, with respect to the executor, I mean, it's not every day that a person's attorney dies on them. And it's certainly a situation where a client might be confused about what to do and where to go. I mean, he's certainly not a judge in
Not
the
just a client, he's a lawyer and he's a judge, and he's held to a higher standard than the general public.
Yes, he is held
Was there
to a
evidence that he
higher
asked the decedent's firm for someone to be put on the case to get his file?
I believe at the March 7th appearance, there was some discussion of that. Certainly, Your Honors, I think as a bottom line, I think that it's fair to say that there was not full cooperation here, that it was reasonable for the commission to find that Judge O'Connor did not cooperate. But what I want to go back to is, when can non-cooperation be used to elevate a sanction, and particularly to elevate a censure to a removal, which is a huge step? It's a much bigger step than elevating an admonition to a censure. And the Kiley case spoke of lack of candor and failure to cooperate as two sides of the same coin. That a judge facing an investigation was in a, quote, unenviable position of either not speaking and being penalized for failure to cooperate, or testifying and risking the commission elevating a sanction for lack of candor. And the Kiley case was the lack of candor side of this, whereas this case is non-cooperation. But I would argue that the caution against elevating the sanction based on the investigative process should apply equally. I mean, first of all, if it's a choice
But
between...
don't we have to look at all the circumstances? Don't we have to look at the charges that were brought regarding his conduct on the bench? Don't we have to look at his prior censure? And can't we consider as a part of the totality of the circumstances, if you will, and the public confidence in the ability of this judge to do his job, look at it as a whole? And so what you're suggesting is that the lack of cooperation was, the one thing that resulted in a sanction. But what if it's just a part of everything?
Well, Your Honor, I actually think I'm in firm ground in saying that it is the one thing that resulted in removal, because the commission has effectively conceded as much. In the oral argument before the commission, counsel said that without the non-cooperation, the benchmark would be censure. And in fact...
But that's not contrary to my point.
No, and I do agree that the totality can and should be taken into account. But I would submit, as, given the caution in the Kiley case, that when you're taking a step from censure to removal, unless the underlying conduct is very close to what would have justified...
So let's say we agree with you that partial non-cooperation is different in kind and warrants a different sanction than complete failure to cooperate, right? Why isn't a pattern of non-cooperation, though, of a different animal? Why doesn't that equate with just not cooperating at all? So is there a certain intentionality, as Judge Stein has noted, that the commission found?
Well, because the purpose of any sanction in any commission proceeding is not to punish the judge. It is to vindicate the public right to have judges on the bench that it can have confidence in, and to gauge judges'
But how can there be
fitness.
public confidence in a member of the bench who undermines and intentionally fails to cooperate with a body tasked with determining whether or not the judge has violated the law, ethical standards, is tasked with deciding what would be an appropriate sanction under the circumstances? Where can the public have confidence in that particular member of the bench when they don't abide by the rules themselves?
I'm not at all sure that the public would lose confidence in a judge who remains silent. I mean, the popular culture is that you have a right to remain silent. And I appreciate that this is a different kind of case, that in a civil proceeding or an administrative proceeding, such as before the commission, an adverse inference can be drawn. But I think that a public who is steeped in the culture of Miranda is not going to view remaining silent in the face of accusation as some sort of dereliction or moral failure.
But we're still back then to our original problem, which is if the judge doesn't cooperate, how can the commission do its work and how can we do our job?
Well, Judge, the commission did its work in this case. It heard from many witnesses. It heard in writing from the judge. In fact, given that the judge professed a lack of further recollection, it's very doubtful that his oral testimony would have really added to the
Let me take it a step
submission.
further. Judge Stein was talking about the totality of the circumstances, which is a good point because here we have a short time left in the judge's term, and how are we not to view the delay as simply an attempt to run out the clock before the judge leaves the bench? In other words, it was a calculated strategy.
Judge, by the time, when the hearing was scheduled, when this alleged non-cooperation occurred, this was during the early part of 2017. At that point, the judge's term had a year and a half to run. That it's very doubtful that misaddressing an envelope or requesting an adjournment from March 7th to 29th or from January to March is part of a strategy to delay things all the way to the end of 2018. And look where we are now, Judge. We're not at the end of 2018 yet, and it's already at this stage. And certainly I would also argue that any such intent is undermined by the fact that counsel did appear in right before the hearing was scheduled. Obviously not as expeditiously.
Asked for an adjournment, right?
The counsel did. That wasn't Judge O'Connor asking for the adjournment.
I see.
There is no suggestion by the commission that the counsel's reasons for requesting an adjournment were anything other than bona fide.
Why didn't he just show up and preserve his argument on the service?
Pro se litigantitis, Judge. I'm certainly not saying he's handled this well. But what I am saying is this is not a removal case.
Thank you, Mr. Edelstein.
Thank you, Judge.
Counsel?
Good afternoon, Chief Judge DiFiore. Good afternoon, Your Honors. May it please the Court. As the Commission found, a Commission request that a judge appear and give testimony during an investigation is not an invitation. Judiciary Law 44.3 gives the Commission the authority.
Is it in and of itself enough to remove a judge?
I think that that's what you should hold. I think it's a red line. And if you look at the Commission's cases, you see in cases like McAndrews in 2014 and McCall, we have judges who fail to cooperate initially. We have judges who don't answer our letters. It happens. But if a judge comes around and does appear and give testimony, both McAndrews and McCall were censures. The failure to initially cooperate was an exacerbating factor, but it didn't result in a removal. So
what if there were allegations made about a judge's conduct on the bench? And the Commission did its investigation, and the judge refused to cooperate, and ultimately the investigation doesn't support the allegations of misconduct on the bench. So you wouldn't be inclined to
understood, and not conceding
or
that
minor things, errors.
Not conceding that that's what we have
No,
here,
no,
but
no,
I understand the question,
it's
and
a
I think the
hypothetical.
answer still is it must be a removal. I can't stress enough how important a judge's testimony is in a Commission's investigation. Every year we have many.
So even with a detailed response, it's the failure to come and testify. Even if he would not say anything at the hearing.
The statute doesn't actually require a judge to answer our letters. That's something that's required because of high standards of conduct and cooperation that's expected of a judge. But the statute specifically requires that a judge appear and give testimony under oath. And as I started to say, we have so many cases in which conduct that initially looks troublesome.
So if he provided a written response, that you're saying that's not enough?
I think that's not enough.
Certified under oath?
I think that's not enough. Any lawyer will tell you that there's no substitute for live testimony.
But if his position is, I'm not going to answer any questions.
I don't think that the statute gives him the right to do that.
He must answer your question? He can't take a position where he will not answer a question?
I do not believe that a judge can do that. I don't think that you should hold that. No.
What if he
Kylie-
says, I already answered it, and my answer doesn't change?
Clearly, there are lines. There are judges that can be evasive. There are judges that flout the line between truth and lack of
What
candor.
if they plead the Fifth Amendment?
Well, we have never, sorry, to take that back. We did have that happen once. In 1981, in matter of Carpenter, there was a town judge who was accused of taking funds from the court fund, and he refused to answer questions and took the Fifth Amendment in that case, and he was removed for that. It doesn't happen because the commission's practice when a judge is subject to a criminal charge, we've had that recently, as you know, is that we hold our investigation in abeyance. We don't want to put judges in the position where they have to come and assert the Fifth Amendment in order to keep their rights in the criminal proceeding. So that's why you don't see it. But really, the fact that
So if he had not responded at all, but he actually showed up for a hearing, that you would say is he's come around, he's
still
going to
think
answer
so.
questions now, and he doesn't, well, he's
Right,
not obstructionist
because in
at
an
the hearing.
investigation, when the judge gives you testimony, then you have the opportunity to corroborate it. Yes, it's quite different. And you removed a judge, Cooley, in 1981. And look at your case in Rogers and Cooley. In 1980, there was a town judge, matter of Rogers, in which the judge failed to answer 3 letters. He had some problems with record keeping. The commission removed him. This judge reduced it to a censure. The next year, you had matter of Cooley. The judge didn't respond at all. No letters, refused 2 opportunities to come and testify under oath, and you upheld that removal. And again, the underlying misconduct in Cooley was more record keeping for town judges. I do think that's a bright line. The investigative testimony is so critical. We do have cases that never make it to you because conduct that looks bad is explained and the judge puts it in context, but we also have cases like Bauer, most recently matter of Ayers, matter of Young, in which conduct that may be borderline, when we have the judge's testimony, we reveal a deeper problem that ultimately leads to removal. And so you have cases where you look at judges' lack of contrition or their failure to accept responsibility as being exacerbating. A judge who just tactically strategically refuses to appear and give testimony deprives you of that record, deprives the commission of that record, and it deprives commission staff of the opportunity to prepare for a real hearing. How do we know what witnesses to bring if we don't know what the judge is going to say?
Counsel, you care to address the notice issue?
He admits that he had actual notice of the hearing date. He hasn't even tried to make an argument
Did
to you
you
that he-
comply with the statutory
No.
requirements on notice?
He was given actual notice, and I think that then your cases and in our analysis that that's sufficient, but we did not serve it by certified mail, and we've never denied that.
Why not? Why didn't you comply with the, what's set forth in the
It's
statute?
difficult for me to explain what happened without talking to you about the commission's usual practice and how we do hearing notices. That's not in the record, although I'm happy to address it if the court would find it helpful.
Please do.
In actual fact, we haven't sent a hearing notice by certified mail in years, more than a decade. No one can remember the last time we did. And the reason for that is in the modern practice, we no longer send a judge a demand letter and tell him or her to show up on a date certain for their hearing. Our practice has been for many, many years, a referee is appointed, he or she holds a pre-hearing conference, the parties get together, they work out a discovery schedule, which is always more generous than what's provided by statute, and everyone gets out their calendars and we find dates that work for the referee, the lawyers, and the witnesses. In that circumstance, a certified letter is somewhat superfluous because the judge or his counsel has participated in choosing the dates, so that the referee does what the referee did here, which is to send a follow-up email or a follow-up letter just confirming what the parties have agreed to. In this case, the referee tried to do that, and the petitioner refused to participate in the conference. We should have sent it by certified mail, but that's why it didn't happen, because it's been standard practice not to do it for a long time. Note that the formal complaint, the demand to show up for a hearing, those are also required to be served by certified mail. Those are all served by certified mail or personal in the normal course.
Thank you, Mr. Lindner.
Thank you, Your Honor.
Counsel?
Your Honor, counsel for the commission, in his argument, illustrated exactly why Kiley should apply to failure to cooperate. Counsel argued that sometimes the judge's testimony and what the commission views as his attitude of lack of contrition is something that the commission will used to elevate the sanction. That the same underlying conduct becomes more serious because the commission doesn't feel that the judge
So
is
then
sorry enough.
aren't you questioning the underlying authority then of the commission to require an appearance and testimony? I mean, if what, essentially, you're asserting a right to remain silent, right? But that's not that's not how the system is set up here.
No, Judge, I am not contesting that the commission has the right to require a judge to testify.
But if
Also, the
everybody
same
can ignore it, then what's the point?
Well, as I've said, first of all, the commission has other remedies. It
Well, maybe
can
those
draw an
remedies-
adverse inference.
Maybe those remedies aren't sufficient to enable it to do its statutory and constitutional job
Well,
in all cases.
I think if there were a finding in a specific case that where a judge failed to testify, the commission was unable to do its job. For instance, if this was something where there weren't other witnesses or where there was something that only the judge knew, and then where he failed to testify and where that effectively had the effect of concealing.
They didn't have the benefit of the testimony on the fees, right, on the orders related to the fees, correct?
Correct.
I know that your argument is that that did not bode well for the judge, that worked against him, and that should be enough punishment. But you can see that that is an obstruction of the hearing process.
Judge, they had the testimony from the attorney for the Ryback firm, and they had the orders themselves. And anything, I mean, the only one prejudiced by the judge not appearing and testifying regarding whether or not he gave an opportunity to be heard or what the reason for the fees were, the only one prejudiced by that was the judge. The commission certainly had everything it needed in order to make a finding of misconduct, which it did. Certainly, as we've discussed in the brief, our position is that at most this was a harmless error of law. None of the
Counsel, the commission also take into account, it isn't only non-cooperation, it seems to me. It's when he did interact with the commission, it was abusive in certain ways. I mean, there's an expletive used, it goes a clown show. One letter, it says the blatant lies in your most recent letter. I mean, it's more than just, I'm not going to show up, isn't it?
Well, the commission's determination specifically disclaimed the clown show comment as a basis of decision. Essentially, there was a footnote in the commission's determination that Judge O'Connor was upset at the time. It may have been a response to him feeling someone was following him, and therefore the court is not considering that as part of the failure to cooperate. And I believe the other letter that you're referring to, I believe that occurred during after the formal written complaint and was not part of the charge of failure to cooperate. I believe that to be the case. And I think once the commission gets beyond the four corners of the charge, I think that's something that there's ample case law that it is forbidden to do, to go beyond the four corners of what it alleged.
Thank you, counsel.
Thank you, Judge.